Hello and welcome. You're watching BloombergQuint. Now, over the last 2 years, Indians have been worried about whether we had a right to privacy or not. Now, although the Supreme Court of India has settled that once and for all and confirmed that Indians do have a fundamental right to privacy, those wary of the Aadhaar project still have some privacy concerns. Well, the Indian government has also issued a set of draft data protection norms considering the informational privacy aspect. What if I told you that tech giants like Google already have access to a treasure trove of data, and millions of customers around the world are worried that their privacy has or is being violated? The first case stems from a Quartz newsbreak, which talks about how Google has been collecting location data from its Android customers even when their location services have been disabled. We'll explain how they were doing that in a bit, but it's not like iPhone users are any safer. Last week, Google was sued by a group of irate customers in the UK who go by the name You Owe Us over claims that the tech company illegally collected personal browsing data from millions of iPhone users in the UK. The group claims that Google did this by bypassing default privacy settings on the iPhone's Safari browser using something called a Safari workaround. Now, just to understand how serious these concerns really are, we're joined by Peter Swire, Professor of Law and Ethics at the Georgia Tech Scheller School College of Business, and he's also a senior counsel with Alston and Bird. We also have Richard Lloyd joining us from London. He's the lawyer representing the customers in the iPhone case. Gentlemen, thanks so much for joining us on BloombergQuint. Mr. Lloyd, I'd like to start by asking you just a little bit more about the claim in your case and why you decided to take this case up.
Well, customers here in the United Kingdom are starting to get increasingly concerned about how their personal data is being gathered and used. And it very often feels to people here that there's not very much they can do about it. If they want to use apps, if they want to use their phones, then the deal is, and this is how the products are funded, the deal is that you hand over personal data that's then sold on by the likes of Google at a vast profit, $80 billion last year alone in revenue for Google for their advertising business based on people's personal data. Now, there is a very clear law here in the UK that says that companies like Google, in fact, any organization, can't process or use people's personal data without their consent. And what we're saying is that back in 2011, 2012, Google bypassed the security settings on iPhones and were able to track people's use of Safari on their phones. That was a breach of the data protection law here. And they need to be held to account. And what we'll do is take them to court here on behalf of everyone affected, about 5.4 million people. And we will be asking the court to give them some redress.
Lloyd, just to understand a little bit more about this case so we can set the background out there. This was a cause of action that arose in 2011, 2012. Some would say that, well, it's been, 5 or 6 years since the cause of action arose. The first thing I want to ask you is why now, after so many years? And two, there's nothing barring you, of course, in terms of limitation.
Well, we're within the limitation.
Right.
But importantly, the Court of Appeal here heard a case of this group of people affected in exactly the same way, 4 people. And they ruled that two things. First, that the jurisdiction question, which Google were challenging, meant that Google could be taken to court here in London. And secondly, that the kind of data that was being gathered did amount to personal data for the purposes of the law here. So we are in many ways following on from that case. That was settled for this much wider claim for everyone else that was affected in exactly the same way.
You know, and I'd like to take that point to Mr. Swire as well. Mr. Swire, thanks so much for joining us. I want to actually understand from you that, well, clearly, the way Mr. Lloyd pointed out, there are privacy concerns with this case in the UK. But given that it's not just Google, given that these large companies have access to such massive amounts of customer data, and judging from what Mr. Lloyd said, it doesn't really matter if it's an iPhone or an Android device, because there's massive amounts of data that's really, up and vulnerable and actually available to these companies.
Well, yes, that is, and we have these amazing services that ordinary people get to use. I'm using Skype to communicate to you from the United States to India today. I have a traffic application on my phone, so when I'm driving through the heavy traffic in my city, it tells me the best route and it saves me time getting to work. So we have these amazing new things that happen. A lot of them work by getting information about us. They know where we live, literally. They know where we work. They know a lot of things about what we do when we're on the internet. The problem that Mr. Lloyd was talking about is it looks like Google went across a line very possibly. I think they've admitted that. And they were doing things in some ways to hack into the Safari browser. Google would have said at the time they were just trying to make it work with another operating system, with another browser. But one problem is when the companies break the rules. Another problem is just how much should these apps be used? Are they the right thing? Is there too much data being collected? And Europe in particular has stricter rules on that than the rest of the world. And they're putting stricter rules into place again in May for just what other people have seen as normal business operations.
Right, Mr. Swire, but when we're talking about that, I'd also like to refer to the Android location case, because it's interesting there, because users clearly have switched off their location services. And of course, Google was still relaying that data back to its servers. They've put out a statement as well when we did reach out to them. And I'll get that statement up on the screen very soon. But what becomes, and there is, to ensure messages and notifications are received quickly, modern Android phones use a network sync system that requires the use of MCCs, mobile country codes, and mobile network codes. In January this year, we began looking into using cell ID codes as an additional signal to further improve the speed and performance of message delivery. So, well, their defense really is that it was better in terms of we were enhancing the delivery service for our messages, but just to understand from you, this isn't the only time a major tech company has been accused of something like this, because in Uber's case as well, be it Android phones or iPhones, Uber, back in August, had to officially roll back a service where they were tracking your locations 5 minutes, even post your ride completion. So it becomes a cause for concern, and also when all of us actually tacitly accept some of these permissions, is there a foolproof way to ensure that these companies don't misuse such information around the world?
I think there's two things. One is, are there technical measures? Are there measures you can use to turn off location tracking in your phone? And a lot of times people have a switch on the apps that lets them turn it off, especially more in the iPhone than in Android. A second question is, are the companies breaking the rules? And Mr. Lloyd is saying that they broke the rules in his case, and there's been some other cases where the companies have broken the rules. In a lot of ways, ordinary people, the bigger issue is, what should the rules be? And India is beginning this discussion after Aadhaar about what the rules for privacy should be in India.
Right. And also, Mr. Lloyd, you've been taking up these cases for the last 25 years. I want to understand from you whether this is just the tip of the iceberg, because Facebook, Apple, Twitter, Snapchat, the way we're discussing with Mr. Swire as well, we share personal data and very sensitive data with all these companies on a daily basis. And the objective of your representative action, per se, seems to be to hold such mega corporations to account.
Well, you asked me quite rightly earlier, why now? And I think we're reaching a point where consumer trust in what these very large tech companies are doing with people's data is starting to get very quickly lost. And secondly, people feel powerless about doing anything about it. The regulator in my case, in this country, in England, hasn't done anything about it. And so what we're trying to do here is to draw a line, send a very clear signal to the Silicon Valley tech giants in particular, who have a very strong business here in the UK, that if they breach the data protection rules, if they step over that line, then they are liable for that to the people that they've misused the information of. And so we want to equip consumers with a mechanism that allows them to privately enforce the law in case the government or regulators don't do that. And that, we hope, will act as a restraining mechanism on very large companies that seem at times to behave as if they're above the law. So it's very important on the substance of this case itself, but also the wider principle of what it might mean for future consumers who have this kind of misuse of their data done by companies other than Google.
You know, it's interesting you say that, Mr. Lloyd, because in the EU, what I understand, well, in Europe, there's a very strong set of data protection principles which have actually been studied by the Indian government as well when they're coming out with their draft policy as well. But what I want to understand from you is that the course that you've adopted and the customers in the UK have adopted is, well, a representative action or like a class action. What I want to understand is, well, does it have to come to that stage in the first place, considering such strong data protection principles already are in place, well, in the EU? Because if you think about it, Google has been facing pressure over data usage and privacy for the longest time. In June, the EU imposed a €2.4 billion penalty for actually rigging results in its shopping search service. It's well, obviously risk the wrath of Spanish data protection authorities as well. Facebook has also had an issue with EU privacy watchdogs for targeted advertising based on shared user data. Well, they were fined €150,000 by France's regulator because they were using something similar to what Google seems to have used in your case, which is actually tracking via cookies. Because what I understand in your case as well is that this software or these cookies were installed using a Safari workaround. So this is it is a cause for concern.
It is, and it's not just a cause for concern in Europe, where the rules, as you say, are quite clear. There are two issues here, I think. One is how meaningful is the consent that people are giving to their personal data being used when you use an app, say. How meaningful is that? If you look at the terms and conditions and what companies like Google are asking you to agree to before you use their apps and their search engine and so on, a lot of people don't know about how to protect their privacy. So it's quite right to say there's a kind of technical question here for what people can do to protect themselves. But secondly, if our personal data has such a great value to companies like Google, it's only right when they take that data without explicit consent that they pay some compensation to the customers whose data they took and then effectively sold. And this goes to the notion that if you have fines from regulators, if you have slaps on the wrist, as Google have had in the past for this kind of behavior, there needs to be more than that. There needs to be some direct to the consumer affected compensation, and that's what we want to achieve. So if we're successful in this case, we will establish a court-agreed value for the data that was taken unlawfully, and we will get that compensation back to as many of the people affected as possible. And this, I think, will help to redress some of the imbalance between the individual and these vast firms where, you know, we are the product now.
Absolutely, Mr. Lloyd. This is why, you know, the point that Mr. Lloyd raised about how this is a problem that's not restricted to their case in the UK. It's a global problem. Perhaps they've actually gone to court with this. But even across the pond in the US, there are several concerns when it comes to privacy with these technology companies as well. I want to understand from you, you know, is there perhaps a better way to address this problem? Because when you talk about Google's privacy policy in these cases, or any of these well, search engines or targeted ad-based services, you know, we end up, even when we're installing an app, end up giving a lot of permissions unknowingly, unsuspectingly. Is transparency, well, the answer for these sort of situations, and to make sure that something like this doesn't crop up again?
Well, transparency is part of it, and there's a lot of different pressures on the companies to tell us how their algorithms work, how they're collecting data. I think that India is going to face some important choices if they want to continue to trade with Europe, because these new European rules next year are going to be strict and say you can't send data out of Europe to other countries such as Europe, India, and the United States if there aren't good protections in place. And quite how the pressures are going to work on the companies is not clear. I think the lawsuits that Mr. Lloyd's talking about is one way. We have data breach lawsuits in the United States against Uber and other people. That's another way that when they screw up and have a data breach that you have lawsuits. But I think a lot of it's going to be regulators, and a lot of it's going to be fines in Europe that get much bigger in May. So the companies have to worry more than they did before, that it might be millions or billions of euros, not 100,000 euros. And that's going to put more pressure on the companies to follow their policies.
Right, Mr. Swire, because when you say that, it sounds interesting, because it sounds like, you know, we're having this conversation with you sitting in Atlanta, with Mr. Lloyd in London, and me here in Mumbai. But it seems like it requires a lot more international collaboration to sort these things out and perhaps get a uniform framework when it comes to taking up such cases.
That will be a real challenge to negotiate. The different countries have different views. India doesn't have private sector privacy rules in place really yet. The United States has some, especially if somebody breaks their promise to the consumers. Britain and the EU have the strictest rules. And right now, the global companies are having to spend a lot of time looking at Europe and trying to figure out how they can do their products and do their things in Europe. That's where the biggest focus of activity is for regulation right now.
Right, and you know, also considering Mr. Lloyd is the class representative in the iPhone browsing history case, so to call it. But Mr. Lloyd, I just want to understand from you, what's the next step in a case like this? Google seems to suggest that, well, this isn't a problem, so to speak, but clearly you guys are getting a lot more people in on this representative suit.
Well, there's a procedure here. I mean, class actions aren't as common here as they are in the United States. It's very unusual, actually, for one to be brought on such a big scale, and it's unprecedented for an action to be brought on this kind of data protection issue. But interestingly, what Google is saying, first of all, is that they disagree that this should be a case heard here in London. They want it to be heard in California. So I think this illustrates, and you know, there's been a lot of publicity about this case in this country here. This illustrates the problem. If a company like Google, whose terms and conditions refer to the law of England and Wales, they have a very large base here in London, if they deny that they are entitled, that they should be held to account in the English courts here, that it should all happen in California, the jurisdiction here doesn't reach them, then we have that illustration of the global nature of the problem. I don't think they'll win that argument, and that will be the first argument in the High Court here in London early in the new year, the one about jurisdiction. But it sends a very poor signal to consumers if companies do use procedural tactics like this to try and avoid any meaningful court action by their customers. I think this will contribute to this sense. These are very large firms that shouldn't be as trusted as they perhaps have been in the past.
Right.
That although there is the prospect of much bigger.
Right. I think we're having a little bit of an issue with the audio there, Mr. Lloyd. But your point was very interesting, because Mr. Swire, it's very interesting that that's what Google's saying in this case. Because if Google wants this case to be actually tried in California, or heard in California, it becomes very interesting for anyone who wants to pursue a case like this anywhere in the world. Because from what I understand, the cause of action has arisen in a country, and Google seems to be very keen to take this to California.
Well, Google's perspective, I think, and I've seen this from the companies, is that they operate in 200 countries in the world, and they operate one service. And if they have different rules in 200 different countries, if they have different lawsuits in 200 countries, they can't offer the global service anymore. And the consumer's view is, I live in my country, and I should have protections of my country's laws. And when it comes to companies that are doing business in India, doing business in Europe, I think the trend has been, and probably will be, that they have to follow the local consumers' laws when they're really doing business.
Very interesting insights, Mr. Swire. Mr. Lloyd, thanks so much for joining us from Atlanta and from London. Really appreciate you taking time out to speak to us. And for all of you tuned in to BloombergQuint, thanks so much for tuning in.